Good afternoon. Reminder to everyone that the cases are, unless we've entered an order saying otherwise, the oral arguments will be live streamed and then be placed on the AOC website. Call the first case, please.
Daniel Seth Holliday versus Elizabeth Francis Holliday.
We'll hear from the appellant.
Parties, advise the clerk to reserve 5 minutes for rebuttal.
5 minutes, that'll be fine.
On behalf of the appellant, my first issue, I hope would not be a contested issue, and that is the reference to the minor children by specific names. I don't know that I have a legal authority that supports that, but I do know that most of the time the Court of Appeals and the Supreme Court have taken the liberty of using just a name, or either initials or something other than a child's name. The child, with respect to that, for some reason, the court made a determination that one of the children was at fault for the demise of the marriage, which I, again, think is inappropriate because it was stipulated divorce. And I would move for that to be stricken as well. But that's, again, with regard to that, I think that's, my client would like to see that for his child. With respect to the final decree, there is an issue with respect to income in connection with this proceeding. The income, the income for the appellant was decided two different ways. It was decided for the purposes of alimony as being $31,250. For the purposes of making a determination for child support, for whatever reason, it was $39,661. This is somewhat analogous to the case of Fuller v. Fuller, with which one of you is very familiar, since you were the author of the opinion, and that is that there was no deduction at all from the gross income for reasonable expenses, for self-employment tax, for child care credit, and for health insurance. None of that is on the child support worksheet, which is attached as an exhibit to the final decree. And if, again, with respect to that child support worksheet, that uses the $39,661.
Excuse me for interrupting, counsel. Was that worksheet submitted by parties or prepared by the court?
It's prepared by the court.
Thank you.
That, with regard to that particular worksheet, there was proof put on with regard to all the items in the record with respect to what I've just described, with regard to the items that are at issue, that is the health insurance, the self-employment tax. All of that was put on, and all of that is in the proof. And I'd like to go through, just for the purposes, and I have made just a list of what it is in the final decree. He states in pertinent part on 126 to 127 of the technical record that husband is a 54-year-old lawyer with the McMahon Law Firm. Husband's income and expense statement reflects the $31,250 in monthly income after deductions and self-employment tax, which he has testified was based on his 2021 return. Now, the 2021 return, I also have an excerpt of that, but with respect to that, it has a gross income with regard to that particular return on the Schedule C that is $757,230, which is also, I think, referenced in footnote 8 in the final decree. My point of pointing this out is later on, and subsequently, the court uses that what is on a 1099 as the income from the parties. And in fact, in his final decree, he states in pertinent part, husband's testimony that 2021 was his highest earning year in the past 3 years is supported by his 2020 Form 1040. And there's a paren by the judge of $581,942 in gross receipts. In 2019, Form 1040, $745,286 in gross receipts. That's actually, gross receipts do not support necessarily earnings. As this court knows, you take into consideration what the expenses are to earn an income. And if you reflected on the Schedule C as they did in 2021, where you had $757,230, you had expenses of $377,561. To use, in fact, these numbers to support those earnings is, again, a non sequitur. It doesn't follow. You have to look at what the gross income is on the return and on the Schedule C, and then you also have to look at the adjusted gross income for the purposes of the child support worksheet. I have itemized those. I also would tell you with regard to the tax return for 2020 and the tax return for 2019, the actual adjusted gross income for 2020 is $220,181, and the adjusted gross income for the year 2019 is $315,219. The point being that we used a number that was the highest number of income that my client received in making the determination of the income and expense statement. And we'll talk about that in a minute, but specifically with regard to this, the judge states on page 131, husband is a lawyer with substantial earning capacity evidenced by his tax returns reflecting gross income of more than $700,000 in 2 of the last 3 reported years. Again, that is an incorrect statement in the sense that it's not income. He's commingling or conflating the gross receipts or gross revenues, I don't know what you want to call it, but it's not income. And he says in a footnote, in number 8, husband's lowest earning year was in 2020 when he made over $580,000. Well, that's not correct. I just read you the amount. In 2020, his adjusted gross income was $220,181. His total income was $255,103. I have these sheets. I'm welcome to give them to you, but if you don't need them, that's fine too. But with respect to the continuation in the decree says husband's latest proof of income is Form 1099 for tax year 2022, which reflects a total annual income of $475,932 or $39,661. So if you're looking for where did that number $39,661 come from, it's because he divided what was on the 1099 by 12. That's incorrect. That is specifically what happened in Fuller that this court has already made a determination about. With respect to he says, even considering these payments, husband's proposed monthly income figure of $31,250 affords him the ability to pay a significant amount of alimony. That is incorrect too. Page in my brief, I think it's page 43, I table the pre-tax amount and the post-tax amount of what the payments are. The post-tax amount, if you total the payments of the post-tax amount of what the court ordered here, the court made a determination of $7,000 a month that he would pay in marital debt. If they found it was household expenses of $11,000, which is understated based upon the income and expense statement in connection with this matter, and child support of $3,200 and alimony of $9,500. That is a total of $30,700, and that's post-tax. Remember, our income in this case is $31,250. So a difference, it is essentially a little bit more than $1,000, a little less than $1,000 we're talking about. There's no way that you could pay, he can't live. I mean, it makes no sense. The alimony payment is $9,500. He didn't even elucidate or explain the factors of alimony, which we have done in connection with our brief. The $11,000 supposedly comes from the income and expense statement, but if you look at the income and expense statement and you just add up the mortgage, utilities, automobile insurance, child care, children tuition and uninsured medical, that totals $11,494. And that's before we get to food, recreation, or any other items that are on that income and expense statement, which are, again, it's in the record, it's an exhibit, I think it's 64 to 66. So with respect to, there is a lot to be discussed about this. Unfortunately, I'm running out of time, but I will tell you, I would ask that you read my brief, consider what I have said. This is a travesty. This is unbelievable. Anyway.
You have your time for rebuttal. We'll hear from the appellee.
Good afternoon,
Good afternoon.
Your Honors. I'm Alan Beard from Chattanooga Bar. Regarding income, they wanted to rely at trial on his 2021 income, despite the fact that we're already in late 2023. So we did a pretty in-depth analysis of all of the husband's bank records. It's all in the record. He works for a law firm. The money gets immediately placed into his business account. So we analyzed his 2022 tax returns. I'm sorry, bank records. And the money that goes into his business, it's clear in the record, every single business expense, including the IRS, the only possible deduction is the mortgage would go in. Everything else would go into their personal account, which they shared. And the total that went through that personal account after all the business expenses was $644,700. What's that? Minus miscellaneous deposits, including a couple of SBA loans, a total of 160. So in his net income, we're not suggesting gross, his net income was $484,000 for 2022, far beyond his $31,000 a month that he claimed. Plus, he got an $80,000 bonus on top of that. So $560,000 went through that account, clear money into the household. Now, if you take the 484, that's just about what the trial court landed on in imputation of income. It's $40,000 a month, not $31,250. So, excuse me, I'm a little bit ill. So there was no abuse of discretion in the amount of alimony in this case. It's a 20-year marriage. The most she's ever made was $50,000 in 1 year, years ago. She hadn't worked in 13 years, my client. She had to quit when she got pregnant. Well, she did have one job for like just a matter of months in that whole amount of time. She has very little education. She has a philosophy degree, which she's never used before. And she's got 2 or 3 paralegal certificates. So they argue that this isn't a case for periodic alimony, but it's a perfect fit, really. I mean, a 20-year marriage. She can't be rehabilitated in the normal, according to the statute, she's got to be afforded a standard of living comparable to that enjoyed during the marriage. Well, these two had a very lavish lifestyle, and they had somewhere upward of $4,000 in car payments. And nannies, full-time nannies. So it's impossible to have rehabilitated her into the lifestyle she had grown accustomed to.
Well,
So we would,
counsel, let me ask you, I mean, did the trial court say anything about their lifestyle?
he did.
What did he say?
He said it was a lavish lifestyle and that they overspent.
And they overspent.
He said that.
Okay, well, if they were overspending during the marriage, how after the marriage are they?
Well, she didn't get what she,
You understand what I'm trying to say about if you're living a lifestyle and it's based partially on borrowed money, you're spending more than you can. Are you saying that she should be entitled to continue that same lifestyle?
well, that's kind of an arguable position. That the statute doesn't really say that you're entitled to live a comfortable lifestyle as you had during the marriage, as long as you weren't overspending. I mean, but she was asking for 16 grand a month, and she got ultimately 6. She got 9, which pairs down to 6 next year. So I wouldn't say that there was an abuse of discretion there. But just on some there's also, I mean, as far as the alimony factors, I mean, I think the court did go through them, quite lengthy. If you look at the final decree, 20-year marriage, he discussed the standard of living, relative fault of the parties. The husband had a girlfriend that he dropped a bomb on my client back in March of 2022, that a woman that he had been seeing for 4 or 5 months, when my client was under the impression that everything was good in the marriage. And so there's also evidence he was spending money on an ex-babysitter for like 7 months straight, $500 a month, for no apparent reason that we could decipher. He also spent $60,000 on his girlfriend, which he developed. We got phone records where he was basically talking to her every single day for 4 or 5 months, for hours, literally hours on end. It's in the record. And then he wrote her a check for 60 grand for reasons we don't know. But he certainly had enough money to throw around to these women. And I think the court did consider that. That was a big factor in the court's consideration. So if you look at the final decree, I think the court went through the alimony factors quite concisely and did a good job of it. They want to, one part of their brief, they seem to take issue with the fact that the minor children, particularly the oldest child who had mental problems, was that information came out in trial. But they want to argue a trial and then brief the fact that my client had mental problems, but they don't want to let her explain why. Well, not to mention the fact that a lot of information came in at the trial level about my client's mental capacity and mental problems she was having because of the oldest child. With no objection, by the way. And now in their brief, they're wanting to argue somehow that the trial court erred in letting that information in. Excuse me, folks, I have cancer and I'm just not doing well today. But and like I say, we put pictures in at trial where the minor child, the oldest child, had been physical with my client. Well, no objection there. But now they want to, in their brief, they want to argue that somehow or another that we never should have got that in. But there's quite a bit of information in the transcript about the minor child and all the problems. It was a big problem in the family. It really was. But it certainly didn't warrant the husband stepping outside the marriage with other women. They also take issue with that the father didn't get, the father's been paying school tuition. And they're taking issue with the fact that he didn't get a deviation for that. But we've shown in our brief that the judge has discretion to do that or not. So then they come back and say, well, he may have discretion, but he didn't articulate that what his thinking was when he did it. And I don't think that's required. They never asked. Nobody asked him to deviate down from the school tuition. And with the huge disparity of income of these parties, basically $0 and $600,000 a year, I don't think you could say that the judge abused his discretion by letting the husband eat those tuition costs. Very similar for work-related child care. I questioned in my brief, they're saying, well, he should have got credit for that work-related child care. Well, the problem is it wasn't work-related. And the other problem is he's not required to pay it. In the brief, in the parenting plan, which was submitted for trial docs for the trial, he does state that he was paying the nannies, which he was. But in the parenting plan, he's not required to. And so there's nothing in the record that would indicate he's paying her nanny bill after he's on top of his alimony that he's ordered to pay, see? So, I mean, we would concede that's her bill. I guess that's all I have, unless there's any questions.
I hear none.
Okay,
Thank you. Hear the appellant rebuttal.
There's no judicial finding of $484,000. And to suggest that you're going to take SBA loans and count it as income, again, is a misdirection, to say the least. What the court found is he allocated $600,000 of debt to my client because he would have the, quote, ability to pay. He said in his final decree, he said he would be paying $7,000 a month for that. So that's, when I referred to my page number of 43 on my brief, that's the $7,000 that the judge used to amortize the debt. Then the only other time you get above 321 is on the child support worksheet. And on the child support worksheet is the number that is divided by 12 into that 1099 for the year 2022, which is $39,661 on page 140 of the technical record. And the judge himself found on page 127 of this decree that, again, the amount of money that would be, page 126 would be $31,250 for the purposes of determining his monthly income. Why he chose $39,661 based upon that 1099, I do not know, but that's incorrect. Again, to suggest that somehow yes, my client did testify about loans because he was borrowing money to pay debt, which is one of the reasons the judge said they were being irresponsible with regard to this. This is similar to the Eves case that Justice Susano, I think, looked at, with regard to, actually out of Division II of Hamilton County Circuit Court, when Sam Payne was the judge, and made a determination that you can't award alimony if there's more debt than there is income, which is exactly what this case is about. And he gave a nominal amount, that is Judge Payne did. Judge Payne gave a nominal amount of alimony in case the circumstances changed on a periodic basis. And that was, affirmed by Justice Susano in this court in connection with that proceeding. I believe the presiding chief judge sitting here today joined in on that decision. So, again, the Blakemore case that Justice McClarty wrote the opinion about with regard to the deviation in the use of tuition for deviation, he said you must in that particular decision. To suggest that you're going to ignore that, you got to at least consider it. You may not make a determination that there's justifies a deviation, but you got to at least consider that. That was not done, and there was plenty of evidence in the record with regard to that. There's a suggestion on the children. There was an objection to using the children's, we stipulated to a divorce. Why are we getting to the fault of the child? I don't know. But again, we objected to that in opening statement. The judge sustained that objection, but then allowed the testimony later. So again, with respect to this particular case, there is a lot to talk about with regard to this final decree. And again, with regard to this final decree, it is inconsistent in its determination and treatment of the income. With regard to the child support worksheet, there's no analysis. There's none given with regard to the child support worksheet. And with regard to the alimony factors, there is no analysis of it, and there's no determination as how you can have $30,700 worth of expenses after tax when that's going to equate to a much higher number on a monthly basis of $43,000 a month. There's no way that you can afford to live on that. There's no way these people could ever pay off this debt because of that. I thank you for your time.
Of course, thanks to counsel, both sides. We appreciate your briefs and your argument on this. Have a safe drive back to the beautiful city on the river.
Thank you.